Well, here I am on Blackpool Pier. You can see just behind me Blackpool Tower. It's on the west Lancashire coast by the sea, of course, which is just behind me. A pier is one structure that spans water. Another is a bridge, and that made me think of Lord Bridge and his judgment in Lloyds Bank in Rosset, common intention constructive trust case. I thought we'd talk about that whilst we're here. It's a bit windy here, so we'll go inside, find a spot, and then discuss that case. Lloyds Bank and Rosset. Let's go. Okay, so we've come inside from the pier into the relative quiet here. Whilst you have a look at the various scenes of Blackpool, I thought I'd talk to you about Lloyds Bank and Rosset, which of course is a 1991 authority, and the citation is 1991 square brackets, 1 appeal cases at page 107. So this is a pre-Stack and Dowden approach to dealing with property when we're dealing with a married couple. That's as opposed to a cohabiting couple. And this is an important authority because it's obviously House of Lords, and what the House of Lords essentially say, which will meet out in due course, but what they say is that it is at least extremely doubtful whether anything less than direct contributions to the purchase price by the non-owning partner will be sufficient. So of course this is quite a strict approach, one that perhaps looks more towards the resulting trust as a form of resolution for contributions, and particularly a focus towards contributions that are monetary and not in some other form, perhaps like we've seen previously in the cases that had featured the Lord Denning. So here we have a battle for value in Lloyds Bank and Rosset between the husband, who has legal title in his name because of a Swiss trust that we'll see, a family trust, and then of course the protagonists feature the wife. So the husband versus the wife, who's arguing for a beneficial interest in the property. You'll note from the title that the case is called Lloyds Bank and Rosset. So you might query to what extent this dispute between the two parties, the husband and wife, in terms of a battle for value, actually might reflect instead a battle for value between the bank, Lloyds Bank, and then the married couple in some way. So the property, the subject matter in this case, was a dilapidated house which was purchased for £57,500, and that was called Vincent Farmhouse, which was in Manston in Kent. And this semi-derelict home was purchased by the couple as a home for themselves and their 2 children. But the purchase was effected with monies from the husband's family trust in Switzerland. And the Swiss trustee, to the knowledge of both defendants, insisted on the acquisition being the husband's sole name. So I suppose we could say this is a form of primogeniture, the idea that the trust, the Swiss trust, is causing that specific disposition to be made in the husband's name because it's trying to control that value. So the defendants were given permission to enter the property with builders to undertake various bits of renovation work before the exchange of contracts, and then builders began work excuse me, in November 1982. But the wife herself carried out some decorating work. It was adduced almost daily, and also obtained necessary materials and generally urged on the builders. Come on, builders, get cracking with this construction. That was the 7th of November there on in, but on the 23rd of November the contracts were exchanged. Later on, though, and this is a salient point for us to think about, the husband, as you know, the sole legal owner of Vincent Farmhouse, obtained a loan for £15,000. And that was, we're told, without the wife's knowledge. So he obtained the loan and also permission from the plaintiff bank, namely Lloyds Bank, to overdraw up to £15,000. So, of course, what this means is that the bank are now interested in the property as a form of security. And the husband, as you know, has the property in his sole name, but the bank took a charge on the property, namely some protection. Well, as I've intimated already, the wife made no financial contribution to either the purchase price of the property or to the cost of renovation. And the transfer and charge were eventually registered on the 7th of February 1983, and the family moved into the property on the same in the same month. We're then told that the couple get into matrimonial difficulties. Indeed, the husband allegedly, did leave in May 1984, and the wife and children remained in the property. So now the £15,000 loan becomes interesting or salient because a formal demand for repayment of the loan was made. And of course the bank tried to claim possession and an order of sale pursuant to the charge. The husband, of course, doesn't resist the claim, but the wife does. She adduces defence that she has a beneficial interest in the property under a constructive trust, and that she qualified as an overriding interest pursuant to Section 71G of the Land Registration Act 1925, because she was in actual occupation of the property. Well, at first instance, before Judge Scarlett in the Thanet County Court in May 1987, the judge ordered that the bank should be given possession of Vincent Farmhouse, and he therefore rejected the wife's claim that it had been expressly agreed between the husband and herself that the property was to be jointly owned. Well, this is interesting because, of course, there's 2 points to note at first instance. First, to what extent do we think or consider that the husband and wife's marriage difficulties might have in some way been erroneous as a method of getting the value from the house through the wife asserting this form of equitable interest? In other words, we know that the legal title sits with the husband, and that he's on the hook and has used the house as a charge or for a charge against the bank, but then he gets into difficulties. He perhaps sets up a position whereby the couple are in difficulties, thus allowing her to bring an action that helps remove value from the estate which otherwise would go to the bank. And that's particularly interesting because at first instance, Judge Scarlett did find that there had been a common intention between the parties that was formed prior to December 1982 that the wife should have a beneficial interest in the property under a constructive trust, and that she had acted to her detriment by virtue of the work that she had done towards the renovation of the property before that date. She had acted to her detriment on the faith of that common intention. So this is kind of Denning-like we've seen before, Eves and Eves, Hussey and Palmer, etc., in the sense of how somebody may have acted. But the judge at first instance concluded that as she had not been in actual occupation of the property on the date, her equitable interest as against the husband was not protected as an overriding interest pursuant to Section 71G of the 1925 Land Registration Act, so it was not able to prevail against the bank's charge. So at first instance, the bank win. Then goes up to the Court of Appeal, which allowed the appeal by the wife. So Purchase, Nichols and Mustill, Lord Justices, allow the appeal and refuse the bank leave to appeal. So it's 1-1 at the moment, and then we go up to the Lords, which, as I've already intimated in my introduction, was bad for the wife. So here we have Lord Bridge, Lord Griffiths, Lord Ackner, Lord Oliver and Lord Jauncey as well, sitting as an appellate committee of the House of Lords, as our court then was, who, as I say, fined for the bank. So that's to say, they hold that the wife's activities in relation to the renovation of the property in November and then the date of completion had caused the first instance judge to base an inference of a common intention that she should have a beneficial interest in it. But they go on to say that it had been insufficient to justify an inference, and accordingly the judge's finding that the husband held the property as a constructive trustee for himself and his wife could not be supported. And then, of course, and this is critical, Lord Bridge goes on to say that anything less than money will not suffice and not found a common intention. As I said in the introduction, it is at least extremely doubtful whether anything less than direct contributions to the purchase price by the non-owning partner will be sufficient. So, when we're thinking about property that's owned in this way by married couples, that's to say sole legal owner cases, when we're thinking about the area, at least through the prism of the House of Lords and Lord Bridge in Lloyds Bank and Rosset, we should think about two factors. Firstly, evidence on the one hand of express discussions which are capable of establishing an express agreement or an express representation that the partner who was not the legal owner was to have an interest in the property. And then secondly, evidence on the other hand of conduct alone as a basis for an inference of a common intention to share property beneficially and giving rise to a constructive trust is probably, in their view, not sufficient, ergo monetary contributions. So we'll look at how Lloyds Bank and Rosset has been treated in subsequent cases, particularly when we come to Stack and Dowden and Jones and Curnow, and see if the somewhat rigorous approach of the Lord Bridge has been ameliorated by those cases. So until then, goodbye.